But by the way, I have this page up about other charges just so you can
Okay.
see this. Page 50, basically the judge is asking, she says, is there an ongoing investigation here? Mr.
Yeah.
Weiss, page 50. He says,
Yep.
there is. Did you hear that, everybody?
Yep.
There is. This is not the end of it for Hunter Biden. And she says, may I ask then why? If there is, we're doing this
You may
piecemeal?
ask.
Like, what the fuck are you even doing here? Which
Yeah.
is a great question for Hunter's lawyers. And I don't know if
Right.
that was news to Hunter at the moment or not, but it just
Oh, I'm
sounded
sure
like
it
it
was.
was. Yeah.
I am sure it was.
So
Yeah.
she says, may I ask then why the fuck we're doing this piecemeal? She didn't use
Yeah.
the F word. That's
Right.
my purview. And Mr. Wise, the U.S. the government's lawyer, says, Your Honor may ask, but I'm not in a position where I can say. And so
And then she
she's
was
like,
like, sit your ass down then.
yeah. And she's like,
It's so
look,
many
at that
words.
moment, she's looking at Hunter and his lawyers going, what the fuck are you guys doing?
Exactly. Exactly.
And I'd love to know that answer myself. Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hello, everybody. This is Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona, for another thrilling episode of Set for Sentencing, again with my great friend and distinguished colleague, Mark Allenbaugh, back with us. Hello, Mark Allenbaugh. How are you, sir?
Hello, Doug. How are you? I'm doing well.
We had to,
Cooler
yeah,
than you.
yes. Well, it's pretty chill today. It was only like 109 in Arizona, but um, we'll get there. We'll get
Dry
there.
heat.
So what are we doing today? We're following up on a podcast we did about the president of the United States, son Hunter Biden. So the last time we talked about Hunter, we talked about his potential guidelines. This was before he went into federal court in Delaware to enter his guilty plea and diversion agreement with the United States. And as everybody is well aware by now, that thing just blew up. And so we thought it would be important to come back to this and talk about why it blew up, what happens next, and probably more importantly, to kind of look at the whole plea process and see if there are some takeaways that we as lawyers or clients might be able to benefit from learning, teachable moments, if you will. From, I always say that all of the lessons I learned the hard way, in other words, from things that went to shit and blew up and mistakes and everything else. And so falling down is how we learn. So we're going to dig into what the hell happened with Hunter. And I was thinking about titles for this episode. The one that comes to mind right now is Once More Into the Breach. And we'll get to what I mean by that. But anyway, and by the way, we did this great podcast very shortly ago, not too long ago, with about Donald Trump's thing. And I got a lot of really interesting feedback about the pseudo sponsor of the podcast, which was Don Fulano Tequila. And so I'm going to keep with that tradition and say this today's sponsor, unofficial, of course, because this is not true at all, but is Lalo Tequila. Lalo Tequila. And why is so Don Fulano was pretty obvious because we were talking about the Don. Why is Lalo, you might ask, the official pseudo sponsor of today's podcast? Listen to this.
Nice. Nice glass too. I'm glad you're using. You have the proper glass, the proper stemware.
Thank you.
For some
Glen
excellent
Cairn.
tequila.
Oh, this smells so sweet, like vanilla. It's just so nice. But Lalo, so by the way, I got a couple. This is not a tequila podcast, but I'm going to make everything relevant to sentencing. You ready? Lalo is named this brand in honor of Eduardo Lalo Gonzalez. He is the son of Don Julio Gonzalez. Does that ring familiar? Don Julio? Because that's the
Mm-hmm.
tequila you see on every shelf in every bar and every liquor store in the country. Don Julio is like one of the most popular tequilas. And Don Julio Gonzalez is the father and of that of Don. That's Don Julio, and his son is Lalo. And so I figured, father and son connection, right? And so we're
I
talking
get it.
about Joe Biden and Hunter Biden, father and son. And I want to also make it relevant to another thing because, these were a lot of very high powered, high priced lawyers that were litigating Hunter Biden's thing. And, they kind of crashed and burned on national TV. And, I always say lawyers are like tequila, that the beautiful thing about tequila is you don't need a fancy bottle, you don't need to spend a lot of money. The very best tequila is the low key, easy bottle and good price point. You know what a bottle of Lalo is? Like $45. And
Not
it's
bad.
and it's 1,000 times better than Don Julio because Don Julio sold out for a gajillion dollars and it's mass produced. So tequilas are like lawyers. Boy,
I have to
what
try
were we
some.
what were we talking about? People are listening, going, you just made me sit through like 10 fucking minutes of tequila talk. What are you doing? So it remains to be seen whether that's going to make it there or not. But the real question is in a podcast called Set for Sentencing, why are we going to spend a whole hour talking about plea bargaining and plea agreements? And the easy answer is the plea is the first sentencing. That what
Yeah.
people need to understand is there are two sentencings that occur in every case. One is the plea and one is the actual sentencing. And the reason is because the prosecutors have so much authority and discretion and power to dictate what goes in a plea, what charges would be filed, what charges will be pled to, what enhancements might exist, what language can be crafted for the fact. So this and the plea agreement sets the entire stage for what comes at sentencing. And in some cases, it limits you as a defendant
Yeah.
significantly as to the arguments you can make or the story that you can tell in mitigation. So that plea document is, especially in federal court, but everywhere, is so damn important. And
Yeah.
we really, really have to scrutinize it because it really is essentially the first sentencing hearing. So
Right.
maybe that's going to
And
be the
90
of our
and
podcast.
97% of all criminal cases are resolved by way of a plea of guilty.
Yeah, right. Everybody pleads.
Generally by with a plea agreement, but we'll also talk about pleading open. Um, that's and one thing too that's often overlooked, and I like your analogy about it being the first sentencing, because it literally can be, because in some cases, once you plead guilty, you are immediately remanded. So your
Mm,
sentencing may
yeah,
start the day you plead guilty,
yeah,
and all that's left at the sentencing hearing is to determine how long, but you're already in. That can
yep,
happen too.
yep.
So that
Great point.
it is the critical point, uh, probably the most critical point in the whole criminal justice process.
Yeah.
Uh, certainly more so than a trial, just by the sheer, uh, just because most cases are resolved that way by way of a plea.
Yeah. All right. So back to what you were saying. In federal court, there's a rule of criminal procedure that gives some guidance as to what kind of plea provisions. It's really, we call them A, B, and C pleas, but tell me what that means.
Well, before we get there, I'd just like to raise this with your listeners and viewers is that if a defendant pleads guilty, he doesn't have to plead to a plea agreement.
Right.
And this is something that is often overlooked, even by experienced practitioners. It's not, oh, I have a crappy plea agreement. My client doesn't want to take it. So therefore, we have to go to trial. That's not the case.
Yeah.
Your client can still plead guilty to the indictment.
Yeah.
If
That's what you were talking about when you said an open. We just
Right.
plead
And so
open,
something that's called either pleading open or straight up.
plead
And
straight
that
up.
what yeah, that means just pleading straight up to the counts of conviction or the counts of the indictment. And you're pleading guilty to all of them.
Why would somebody choose to plead open or straight up as opposed to a written plea agreement, which is like a contract that binds both sides to certain provisions?
Right. Well, because they're given a crappy contract. There's a contract that the government's willing to offer and not negotiate on, and you may be giving up too much stuff. One of the main things that you give up when you plead to a plea agreement, and this does vary by district, by the way, and every district, and sometimes even within a district, there are different parameters on how a plea agreement is arrived at, and what are some of the give and takes in a plea agreement. But what the big thing that you give up, of course, when you plead guilty, whether it's to a plea agreement or open, is your right to go to trial. So you're waiving all of that. But the other thing that you generally waive, and this wasn't always the case, this is somewhat new in the era of the federal sentencing guidelines, is waiving your right to appeal.
Yeah.
And that is a big right. And not just waiving your right to appeal your conviction, which is kind of natural. I mean, you're pleading guilty, you're admitting you did it.
Yeah.
So you waive that
So
right.
why
But
would you challenge that? Yeah.
yeah, so why would you? And there are reasons why you would, but we're not going to get to those right now. But the big thing is you're giving up your right to challenge your sentence.
Yeah.
And as we were saying before, is very often, even if you are remanded at the plea stage, you still don't know what your ultimate sentence is going to be until the actual sentencing hearing.
Mm-hmm.
So the problem very often when pleading guilty pursuant to a plea agreement is you're exposing yourself to a big unknown. How much time am I going to do? Well, except for one limited circumstance that we're going to discuss, you don't know what you're going, how much time you're going to do. So you're kind of guessing and hoping that everything goes right for you.
Let me put a finer point on that about the unknown, because this is very important, and it's maybe a uniquely federal animal about this uncertainty. But one of the main reasons a person would want to plead guilty and give up their right to trial is because they want some certainty about the outcome of their case.
Exactly.
In other words, if you want a real unknown, then just go to trial, because no matter how strong your case is, nobody can predict what your odds are of winning. You never know how the evidence is going to come in. You never know what the jury's makeup is going to be. You never know if the judge is going to make some crazy rulings, but you'll always get a right, if you lose a trial, to keep fighting with an appeal and fight and fight and fight. No. So you're taking a plea, and you have this uncertainty about the sentence. Pleas are supposed to be an insurance policy, which is, I'm going to do this because it's better for me in some way. So this unknown thing has always been one of the biggest thorns in my side. And just to give like an example of how this plays out, if you haven't carefully crafted a plea that says, for example, in a fraud case, that we don't know what the loss figure is, we haven't stipulated to anything or come to any resolution, and then you go to the pre-sentence report writer and they do a draft pre-sentence report and they do a calculation of the guidelines, and they weave in all that relevant uncharged whatever conduct we've been bitching about in every other podcast, and all of a sudden your lawyer said, well, I think maybe your guidelines will be a level 16, and they come back, oh, they're a level 24, and it's 10 more years than you thought you were going to get. What the fuck?
And you may end up getting that, and you've waived your right to appeal the sentence. And so it's just, frankly, in my opinion, and statistically speaking, you gain very little by entering into a plea agreement that doesn't bind the court. But we'll get to that in 1 second. But there's one other reason, of course. There's another big reason, in addition to trying to get some certainty, however illusory it is, as to the sentence you're going to get. It's also for mitigation purposes, to try to get some mercy. We call that acceptance of responsibility. Under the guidelines, if you plead guilty, you generally are entitled to whatever your guideline level is, 3 levels off of that.
Yeah.
And so the point is, there's a built-in incentive, even though it's an insufficient incentive, and there's a lot of problems with it.
Small.
But but nonetheless, there is an incentive to plead guilty, because generally speaking, those that plead guilty get lower sentences than those that go to trial. And there's all sorts of problems with that, because one way to look at that is, well, going to trial, you're not getting, those that plead guilty aren't getting a lower sentence. It's that those that are going to trial, the 3% that decide to go to trial, they're getting hit with what's called a trial penalty, and they're getting more time because they have the audacity to exercise their constitutional rights to trial. But
that's a big point. No, but that's a big point too.
Yeah.
This entire process is unduly coercive.
Yeah.
A lot of times the reasons people plead instead of exercising their right to trial, which is a dying right, it's a disappearing right, 3%, as you said, is because they're terrified about what would happen if they went to trial and lost. And that is because the prosecutor can dump, extra counts or mandatory minimums, or they're worried about not getting acceptance. Whatever the case may be, people have been sufficiently scared out of exercising perhaps the most fundamental right that we have in the world of criminal law under the Constitution, because of the way the laws and the guidelines are written, and because of the abuse of power and the abuse of discretion with the powers that be. So I had to say that. But Hunter, I don't think he was coerced. I think they spent a long time negotiating what they thought was a good plea agreement. Ironically, because we just had this discussion about the unknown and the uncertainty, and you really don't want to sign up to a plea that creates this uncertainty. It was the uncertainty, in my opinion, that gave the judge all the pause to kind of derail the whole thing, because she was looking at this and pointing out that there were some great unknowns in the way this contract was crafted, that apparently the parties, the high-priced lawyers, didn't give a lot of thought to.
Right.
So
before we get into that, though, I think let's talk about the 3 ways to plead. If you're going to plead guilty pursuant to a plea agreement now, the 3 ways you can do so under Federal Rule of Criminal Procedure 11. And this is subsection C under Rule 11. And there's C1A, C1B, and C1C. Now, the way that what A says, C1A is a plea agreement that by its terms, the attorney for the government, the AUSA, can agree not to bring additional charges or move to dismiss charges in the indictment. So that's all that A says. B says that the AUSA, the prosecutor, can agree to recommend not to oppose the defendant's request that a particular sentence or sentencing range is appropriate, or that a particular provision of the sentencing guidelines or policy statement does or does not apply. So the first
they
one,
also I see that they might agree to recommend a certain sentence for them too. Like the government agrees to recommend no higher than the low end of the guideline or something like that. But the key word for B is that it's recommend. Why is that the key word? Well, you've cocked your head aside.
I'm sorry. Well, it's
agree with me that that's the key word.
Well, no, it is. I mean, it is a key word. But what I was going to say is there's very little difference between A and B, practically speaking. It's basically just articulating what the government is able to do in a plea agreement. The A says it has to do with charges. It can agree not to bring other charges or dismiss certain charges. And then B says, with respect to the sentencing guidelines and the sentence, agree to recommend a certain
Right.
sentence or not, or the way the guidelines apply. And yes, you're right. The key word is recommend, because that's all it is. It's not binding on the court. The
Yeah.
parties can agree under provision B, for example, we recommend that the sentence be 60 months, or that the guidelines are calculated this way.
Yeah.
But it has no,
And
it
the
not only does
judge
it not,
could say, "Thank you very much for that recommendation. So appreciate it, and but
right.
no thanks. I'm not following it, and there's not a goddamn thing you can do about it."
Well, it depends on how your plea agreement is negotiated. And plea agreements can come in all sorts of flavors. So yes, generally if you've completely waived your right to appeal your sentence, there's nothing you can do about it. The judge and also the probation office, when drafting the PSR, can completely disagree with what the parties set forth in the plea agreement. And but if you have a limited waiver, and this you see this often too, a limited waiver of your right to appeal the sentence, then sometimes you could still appeal it if the court does not go along with the recommendation. So, for example,
Yeah.
let's say the parties recommend to the court that the court should impose a sentence of 60 months. The parties can agree to waive the right to appeal, or the parties can agree that the defendant waives his right to appeal if the judge imposes a sentence of 60 months or less,
Mm-hmm.
but can still preserve the right to appeal if the sentence is
Right.
more than 60 months.
Right.
So that all comes down to the
Yeah.
negotiation.
Yeah.
But both A and B, the important part is neither A nor B bind the court. And A again has to do with the charges.
Yeah.
Really has nothing to do with the court. It's
Yeah.
all has to do with the U.S.
Right.
attorney
And I'll be
about what
honest
the
with
charges
you,
were. Yeah.
just to confess, in the 20 plus years in federal court, I'd never considered A. And we never even talk about A in plea agreements. Many plea agreements say, as part of this plea, the prosecutor agrees to dismiss this or not bring any further charges, but nobody ever invokes. In
Exactly.
my experience, nobody ever
Ever
invokes
invokes it
11C1A. We're not. So I've never even, until Hunter Biden, I've never even heard of an A plea. I just haven't. It's just
because
not
there's
a
no
thing.
such thing.
It's weird, which is weird, a little strange, but okay.
Right. In practical effect, there really is no
It's
such thing as an A
always
plea.
comes down to the difference between a B and a C plea with
Exactly.
us.
It's a B and a
And
C.
the
A and B are two sides of the same coin.
yeah. And so
C,
tell me, because we as defense lawyers are always, if we can, striving to do a C plea. What is it and why do we want it?
C pleas are a different coin. It's a different currency. And a C plea, frankly, is the only type of plea that's worth anything, in my opinion. A C plea actually binds the court to the sentence that's agreed on. So, and it really doesn't matter at this. Really, what it does is take the guidelines out of the picture. Doesn't matter what the guidelines are. Although the court in the plea agreement, you could still put in the actual guideline calculation that would bind the court as far as the recommendation in terms of how the guidelines apply. But the real key factor here is the ultimate sentence, and that sentence could be within the guideline range, above the guideline range, or below the guideline range. It doesn't matter. So, for example, under a C plea, the parties can agree to a 60-month sentence.
Yeah.
And now, if and only if the court accepts the plea, now the court must impose a sentence of 60 months. There is no longer any discretion. So what a C plea does is take judicial discretion away, which isn't necessarily a bad thing. It could be a good thing because what it provides is certainty.
Yeah,
This is the only time.
require important certainty, right?
Yeah, this is the only time that you get certainty in sentencing, and you don't have to worry about how the guidelines apply, because let's say your guideline range is way up there, 20 to 30 years or something like that. Big deal. You can still agree to 60 months or probation,
Right.
potentially.
Now here's the rub, though.
Yeah.
There is a catch. There's always a catch. There's always a caveat, which is
Yes.
the judge actually could reject the C plea.
Correct.
The real difference between a B and the C is what happens if she does that. Am I right?
Right.
And what's the
That's right.
difference? What's the difference? If a judge rejects under a recommendation under a B plea, you're stuck in that plea. You cannot withdraw your plea, your guilty plea.
Right.
Right. Okay.
Yeah,
But
yeah. Because with a B plea, it's just a recommendation. But with the
yeah,
C plea,
yeah,
if the judge rejects the agreement, now you can withdraw your
yeah,
plea of guilty.
yeah. You can say that's not what I signed up for. I'm out of this
Yep,
plea. I'm going to go to trial.
yep.
Yeah. Plead
Or
straight up. Well,
you plead
no.
straight up,
Yeah. Of course,
or
I
you
don't know
can
why you would
negotiate.
plead. I don't know why
Yeah,
you would plead straight up if the judge already told you she's not accepting the good result that you negotiate. You
right.
know, but
Right. Well,
yeah,
right, you're right. But I mean, it's at least theoretically possible, or you
sure.
can negotiate another agreement, which I
Yes,
think is
yes,
probably
yes.
what's going on right now with
Yeah,
Biden. Now let's get back now. Now let's talk about Hunter Biden. What happened here?
yeah.
So
Well,
this
by the
is
way, well,
yeah,
before we get that,
yeah,
because I
okay,
do, this is practice pointers in a way. We're
yes,
not giving legal
yes,
advice, but we're telling
right,
the truth about how
yeah,
this works. Because
right,
you and I do these cases all over the country,
right,
and we see pleas, and every jurisdiction has their own little peccadillos and
yep,
customs. But the truth of the matter is,
yeah,
there are far too many B pleas where they really aren't making any ironclad promises and anything goes at sentencing. And we see time and
right,
time again that clients have signed their life away for a plea that gives them
nothing,
really nothing.
yeah.
And the question
B
becomes,
please suck, and
yeah,
they
suck.
and they go
And,
open.
they might, some prosecutors will say, well, that's how we do it in this district. Or,
Bullshit.
yeah, I mean, go look at how they do it in other districts and negotiate your go back to
Exactly.
the table and work a little harder and tell a better story or
Right.
something. And if they won't budge, because that's the shitty part of the system, they have the final say, the prosecutors have all the power. That's
Right.
when you might want to consider saying, okay, well, take your plea negotiations, shove them up your ass. I'm just going to plead straight up to the indictment and we'll
Yeah.
see how that goes.
Right.
That may or may not be a good decision in a case, but it's something to consider. And we don't see that happening very often at all. It seems to me like lawyers are wary of that. They're a little scared about doing that. And I think you and I are on the same page that maybe they need to be less scared
Right.
about.
Well, one thing, and forgive me for doing this, Doug, but just to plug something that Sentencing Stats does,
Yeah.
if you ever have a prosecutor come to you and say, "Oh, we just don't do C pleas in our district," or "This judge never accepts them," or anything like that, come to us. We can find out.
Yeah.
We have access to all that data, and we
Sure.
can tell you whether or not
Yeah.
that judge accepts C
Yeah.
pleas or not, or whether that particular prosecutor has ever or not negotiated a C plea,
Oh,
or
yeah.
whether there's C
That
pleas
would be
even in
great.
that district.
Uh-huh.
So we can call the bullshit,
Yeah.
and you
Yeah.
don't have to just rely on the anecdotal
Yeah.
evidence of other practitioners, or most
Yeah.
dangerously, just the word of the prosecutor,
Yeah. And
because
sometimes
they're
the prosecutors say, oh, our judge doesn't like C pleas and they'll just
yeah,
be mad and they'll just reject it. I'm like, put on your big boy pants and
yeah,
justify it if it's worth doing in this case. But, we
yeah.
just need to be a little less, we need to be a little more fearless, I think, sometimes.
Exactly. Yeah, sometimes, right. But
Yeah.
it would help to have empirical evidence. Now,
Yes. And I
I've
don't
never
mind you
seen.
doing that shameless plug. I would have done it for you if you hadn't, but I'll take this opportunity to do my shameless plug. This podcast is unofficially brought to you by Lalo Tequila. Yeah. Someday these tequila companies can call me up and go, I do. I want to sponsor you. That's my dream. It's the whole reason I started this podcast, actually. I say it's about bringing fairness and humanity to sensing. No, it's to get free tequila. So, Lalo, if
Nice.
you're listening and you want to sponsor me, I would not kick you out of bed for eating crackers, baby. Have you heard that phrase?
Yes, yes, yeah, for my old man. Yeah.
From your
Well,
old
I'll
man?
have to introduce you to a friend of mine that I don't know if he still produces it, but he had a line of tequila called Tributo
Oh,
that was out of Jalisco,
I'll
Mexico.
have to look that up on Tequila Matchmaker, my favorite
Yeah,
app. But
yeah. I
what's
might be able to
funny
get you a
about
sponsor.
what's really funny My
Yeah.
my my beloved wife, Rachel, she eats crackers in bed all the time. Like
And you
all
don't
the
kick
time.
her out.
No. And they would never, ever, ever kick her out of bed
The
for
only
eating
other
crack.
person that ever said that is my old man, and he was from Ohio, believe it or not. So I've
Well,
never heard that saying.
Midwestern boy in my heart and my bones.
Yep.
So boy, oh boy, we got distracted again. Okay.
Yep.
So have we
So,
done A, B, and C? And now we're
yeah,
gonna Hunter.
we've done A, B, and C. There's also, by the way, there's one other. There's pleading nolo contendere. That's another way you can't plead guilty. Um,
Which they never let you do in federal court either. Almost never. Almost
well,
never.
it's provided by the rules, but you need to get the court to sign on to it, and it's very difficult. And they're very rarely.
Prosecutors hate that. And I
Yeah,
don't know why.
prosecutors say it,
I
and
don't know why.
so.
I don't know
But
why.
that is another way. But the predominant way of pleading guilty in federal court right now is through the B plea. And
Yeah.
if anybody gets anything out of this podcast, the better option is either negotiating a binding C plea
Mhm.
or pleading straight up. And the only
Yeah.
time that pleading straight up is really going to bite you in the ass is if there is a statutory maximum or a mandatory minimum on the line. So, for example, if you're given the choice, and this isn't legal advice, obviously, this is just an
Yeah.
example.
Yeah.
But if
Yeah.
you're given the choice between pleading to a single 371 count conspiracy, which carries a 5-year stat max, you can plead guilty to that pursuant to a plea agreement, or plead straight up to that same to two of those counts. Well, pleading straight up to two of those counts, your overall stat max is 10 years, so you have much greater exposure versus just 5 years with a single count under a plea agreement. In that instance, it may be better, not always, but it may be better
Yeah.
to plead to the plea agreement than pleading straight up. And the same thing if you're looking at a mandatory minimum of 5 or 10 years or something like that. That may be a good reason why you want to accept a shitty plea agreement versus an even
Yeah.
worse result.
Because they may dump the charge that has the mandatory and give the judge more discretion to go lower than the 5 or the 10 year
Right. Yeah,
minimum that
or
they would have
they
to go. Yeah.
they limit the counts. They limit the
Mm.
counts of conviction, so you have a low statutory maximum. That's
Mhm.
another reason. But so generally speaking, though, setting aside the issues with the mandatory minimums and statutory maximums, the C plea is really the way to go. There needs to be more C pleas, and
Yeah.
really more open pleas
And more
than there are
trials,
B
to be
pleas
honest.
and trials. And yes, exactly, and more trials.
Because
Yes.
we have clients, and I was gonna say so many. I don't know if I would say so many, but I would say many, but not infrequent, at least, where
Yeah.
there really is a strong defense at trial. They very likely didn't commit the crime that the government is accusing them of, and might have been able to prevail at trial had they chosen to do so, but were still so goddamn terrified that it could go the other way that they've now decided to enter into a plea agreement for a crime for which they may not even be guilty.
Yes.
And if there anybody out there who's listening and doesn't know this system, thinks it's crazy concept that somebody would plead guilty to a crime they didn't commit, I'm here to tell you it in all over the country every single day that is happening.
Yeah. Yeah.
Every
Yes.
single day that is happening.
Yes.
And that is for a lot of reasons, but coercive plea bargaining is one of the big ones.
Yeah.
And that needs to change.
Yeah.
I don't know how it's going to change or when it's going to change, but what's happening here is very, very wrong.
Right. Well, I think one of the ways it changes is making sure people listen to us
Yes.
and read Rule 11, so everybody is aware that you are not beholden to the only plea, a non-binding plea offer from the government. You can negotiate those. You should negotiate those, and you should try to hold out for either a C plea or plead open,
Yeah.
and know that those are options. I think
Yeah.
that will help change everything. Just knowing the
Right.
options that you have in terms of resolving
Yeah.
a criminal charge other than trial.
Yeah. Yeah. I mean, Hunter's case is actually kind of a peripheral example of this gun charge, this user in possession
Yeah.
of a firearm, it's been held unconstitutional in at least one district, and it's almost never charged in
I think the
federal
Third
court.
Circuit has held it's unconstitutional. Right? Am I misremembering?
I'm not positive about that, but the point is he had a very defensible case on that charge.
Yeah.
And by the way, this is another thing I noticed, a little nuance, but maybe worth noting. A cleaner charge, easier charge would have been a false statement charge on this, because when you buy a gun, you have to fill out a federal firearms application. And on that form, you have to avow under penalty of perjury or false statements that you aren't a felon and that you're not a user or addict and, currently using drugs or whatever else. So that means that Hunter Biden lied on the form to get the gun because he was a user at the time he possessed that gun. And that would have been a much cleaner, totally legit, constitutionally sound charge. Why wouldn't they tag him with that charge instead of the gun charge? And I would say simply just for optics, they want to dirty him up. They want to make him look
Yeah.
a little bit scuzzier by saying, "Oh, this isn't about filling out a form. This is about the drug, crack smoking, disgusting gun-toting Hunter Biden who's doing all this stuff." Like it's just on its face, it's a dirtier story. And by the way, we see this in the plea agreement too. If you look at the factual basis, which are
Yeah.
the facts that constitute all the offense, this is a this is like a 7-page factual basis, which we never see. Usually it's a paragraph or two, you know, and no, 8 pages. And there's so much gross stuff in there that has no bearing on the offense. So the government is clearly getting something out of this plea agreement, which is they get to feed red meat to the base by showing what a dirty, despicable, dishonest, drug using dope that Hunter Biden is. And that's part of what they're doing here. And if anybody doesn't think that's true, just go read, the transcript from the sentencing, because it is. Sorry. And aside,
Okay. Yeah.
and let's talk about why this plea went south. And I
Okay.
will tell you that when I read this transcript, I felt like I was in bizarre land a little bit. And my first inclination was the judge doesn't know what she's talking about. But then I came around to really feel like she wasn't clueless. She was very careful.
Yeah.
And what people don't know probably is the backstory of why she was so careful, and consequently why this plea blew up. The first thing is criminal experience. So this judge, Judge Norica, super talented, well credentialed, and she is the whole deal, order of the coif, top of her class, big law review, big firm for most of her practice in Wilmington, Delaware, doing what? Patent law.
Yeah.
That's her background. That's her experience. A lot of judges come from U.S. attorney. They know criminal law. They know guidelines. She doesn't have that experience. Not a
Right.
fault. That's just a fact.
Right.
And then she's only on the bench for 5 years. Now, in
Yep.
a normal court district jurisdiction, 5 years is you're going to see a crap load of criminal cases come through the docket. But
Right.
of course, doing the stats, Mark Allenbaugh, you
Yep.
have a different story with that, right?
Yeah, it's a very interesting story. So Judge Norica, she received her commission on August 9th, 2018. Since that time, she's overseen 1,774 civil cases, but
Which seems like a
only
lot.
that's
It's
a
a very,
lot.
very busy court for Delaware.
Yes, we're
But
Delaware.
but people know this probably. But the reason why there's so many civil cases and it's such a busy court is because that's where all the incorporations happen. Most companies incorporate in Delaware. So there's
Right.
business litigation. It's civil
Lots of
litigation.
business, lots of business litigation. So she had 1,774 civil cases, but, and here's the eye opener, only 60 criminal cases. That's
Wow.
basically 12 a year, one a month
Mm-hmm.
since she took
That's
the bench. So that means
that's
only
got to be
three. Yeah.
The lowest in the country, right? That's got to be by far
Well,
the
it's
lowest.
low. Only 3.3% of her docket, therefore, comprised the criminal case. 3.3% of her docket comprised criminal cases. So I went and I looked like, well, maybe it's just her, something about her. She doesn't take criminal cases. Well, I looked at Judge Gregory Williams, who's also on the district court for Delaware, the U.S. District Court for Delaware. He received his commission. He hasn't been on the bench as long. He received his commission on September 1, 2022, Trump appointee. He's overseen, and so he's been on the bench less than a year. He's overseen 185 civil matters and 0 criminal matters.
What?
0. Okay.
Wow.
So I thought what's going on here? Surely they have to have some more criminal cases than this in the District of Delaware. So I went to the Administrative Office of U.S. Courts and got some data there. So from March, and this is the latest data available, from March 1, 2021 through March 31, 2022. So for that March 31, 2022, so that 1 year period spanning 2021, 2022, latest data available, there were a total of 1,836 civil cases in the entire District of Delaware, and only 84 of them were criminal cases. So criminal cases accounted for only 4.4% of the overall docket for the District of Delaware during that 1 year time period.
I don't get it. I mean, I get why there's so many civil cases, but I don't get, like, nobody's committing crimes in Delaware, or they're just not enforcing them there, or they're so scared of the president Joe Biden law and order that they wouldn't dare commit a federal crime in his home state.
You know what? Apparently that's the case, because I went out and I looked at other similarly situated districts. So I went down to let me see here, what was it? The Eastern District of North Carolina. And the reason why I chose the Eastern District of North Carolina, of course, it's somewhat geographically close to the District of Delaware, but it also is about the same size population-wise. The District of Delaware encompasses around 1 million inhabitants, 1 million citizens. Eastern District of North Carolina is about 1.4 million. So, roughly the same size. For that same time period, March 1, 2021 through March 31, 2022, there were only 1,604 civil cases. So that's less than the District of Delaware, which had 1,836. So over 200 less civil cases during that same time period. But where the District of Delaware only had 84 criminal cases, the Eastern District of North Carolina had 1,380 criminal cases.
Wow.
So that's, in other words, about 46.2% of their docket. Eastern District of North Carolina, again, about the same size as the District of Delaware, 46.2% of its docket was criminal, whereas Delaware only 4.4%.
For those of you who are listening to this podcast and not watching it on the YouTubes, that's just fine, because Mark Allenboss screwed me. He didn't bring any fancy ass charts and graphs and box and whisker things to this discussion.
Oh, sorry, Doug.
He's just throwing out a bunch of numbers, and
now, I know, and you know what? And you're right.
Now I'm bored, and I need more deliciously dangerous Lalo tequila. No, I'm not going to drink any more tequila. Now this podcast is brought to you by Vitamin Water Zero, full of essential nutrients. I get it. There's more. Oh, good. Yeah. There's some more numbers. Please.
Let me just round this out. Let's just go nationwide for that same 1 year period, March 1, 2021 through March 31, 2022. In that period, in all 94 districts throughout the United States, there were 309,102 civil cases. There were also 70,957 criminal cases that were commenced during that same period of time.
Yeah.
Thus, nationally, 23% of the nation's overall federal docket was criminal.
Yeah.
So you almost use that like as an average. You would expect on average, in other words, in any given district, more or less 23%, some
Yeah.
lower, some higher, but only 4.4% in the District of
Yeah.
Delaware. That's really
Yeah.
low. And
Right.
some of the judges haven't even done a criminal case. And our judge here, Judge Norika, she's only done 84 in the last
Yeah.
5 years that she's been
Yes.
on the bench.
And
So she doesn't have a lot of experience.
and we talked about this on our last podcast about Hunter Biden,
Yeah.
but the ridiculously low number of criminal cases in Delaware that would involve a diversion plea. So
Oh,
she's
yeah.
probably never, not only has she only seen 80 some criminal cases in her career, she's probably seen zero cases
She's seen
involving
zero.
a
There is no
diversion.
evidence
So
on any
this
of her
is
documents that she's ever had a
this
diversion
is
case.
new. This is very new ground for her.
Yeah.
And it doesn't mean that, she's incompetent. It means that she's looking at it through her own lens of
Right.
experience.
Right.
And again, this is business litigation. And I pulled something, there's a website called the Vetting Room, which talks
Yes.
about various judges. And I'll
Yep.
just quote because I think it's really sums it up. The federal trial court in Delaware is home to some of the most complex commercial litigation in the country.
Yeah.
As such, Norika, with the depth of her experience, is well suited to this specialized jurisdiction. While Norika lacks the criminal experience to handle a significant portion of her docket, her civil experience more than makes up for this deficiency. And so, what I would submit to you, Mark Allenbaugh, and tell me if you think I'm wrong, but the reason why she ends up rejecting this plea or blowing it up or sending him back to the drawing board is because she's reading this plea agreement like she would read a patent agreement. That is to say, with a fine tooth comb, dissecting every word, every comma, every syllable, because in multi-million or billion-dollar litigation contracts, you've got to do that with a contract, and
Right.
you've got to anticipate. My father always gave me that was a good piece of advice. My father always gave me throughout my life. You need to anticipate. In other words, you got to think down the road. What is this provision going to do to me if this happens? Or, if this goes right, how does this language in this plea help me or completely screw me? And so
Right.
what she's doing is she's looking at this provision, especially, that's why I said into the breach, is maybe the title. She's looking specifically at the provision that talks about what happens down the road, however many months, or it could be up to 2 years, because that's how long the diversion is for. What happens down the road if Hunter Biden is in breach of this deferred prosecution? Because the agreement says, look, we got this gun charge. It's the felony. It's the big one. It's the serious one. But we're going to put it in a drawer and lock that drawer. And if you
Right.
comply with all of the rules of the road that we're going to set for you over the next 2 years, don't use drugs, don't commit crimes, bleep, blop,
Right.
bloop, that drawer remains locked forever. And
Right.
that can never be charged against you, can never be used. It dies.
Well, Doug,
But
but
yeah,
I'm sorry to interrupt you, but before we get to that, though, that is one reason why the plea agreement fell apart. But the other reason had actually to do with what we were talking about earlier, the difference between A and B pleas. And she was really hung up on that issue. And as you and I have discussed offline before, most judges don't get so much into the weeds on issues like this. But then again, judges very often aren't diversion agreements, pretrial diversion agreements are stuff that judges very often are not even involved in.
yeah,
So this is something rare for the federal judiciary as a whole. So this is something new to her, but also to her credit, though, she did read this with a fine tooth comb, whereas most judges may not because of the sheer caseload or that they're very, very well accustomed to
yeah, they're not
dealing with plea
contract
agreements.
lawyers in their
And they're
former
not
life.
contract lawyers, but a plea agreement is a contract. And
Yes.
I'm glad that she went and spent the extra time reading every word, trying to give it meaning, and to see where some of the problems were. I mean, her big thing, her big issue that she ultimately had is she wasn't sure Hunter Biden knew what he was pleading guilty to and what the result was going to be of this pretrial diversion agreement, how it was going to work, because he was giving conflicting answers to her when she was posing hypotheticals to him, showing her that he did not really understand this. And as we know, for a court to accept any type of plea, whether it's open or pursuant to A, B, or C, or nolo or whatever, there's conditional pleas too.
Yeah.
That's another way you can plead guilty. But any of those require that the court be convinced that the defendant is entering into it knowingly.
Yeah.
And she was not convinced here. And so going back to the A and B plea stuff, the way I read the transcript is what was giving her some confusion. She wanted to know from the government really what her role was, first of all, right now, with respect to accepting or rejecting the plea agreement. And the way I understood the back and forth between her and the government was that the government was trying to tell her, because this was a B plea, that there really was no role for her in terms of accepting or rejecting it. She basically had to accept it. She didn't have the opportunity to reject it like she would under a C plea. But that is not true. That is manifestly not true. A judge can always reject any plea agreement, even an open plea, a federal judge can, because, and this might be news to people, nobody has a constitutional right to plead guilty.
Mm-hmm.
And so that's, something very important for certainly judges to be aware of, but also for defendants and their counsel to be aware of. And I'll cite for the record, North Carolina versus Alford, 400 U.S. 25. This was from 1970. Trial judge need not accept every constitutionally valid guilty plea merely because a defendant wishes so to plead. And Rule 11 doesn't require that either. Rule 11 of the Federal Rules of Criminal Procedure do not create such a right. And that's according to United States versus Bednarski, 455 F. Second 364 out of the First Circuit, 1971, and also U.S. versus Alvarez, 987 F. Second 77 F. Second 77, First Circuit, 1993. Sorry to make this a law review article, but but just wanted to get those out there.
I will tell you this: I sort of agree with you, but not really, because I think she was asking very pointed questions about the difference between A and B, but eventually she got over that. And what the real issue was this uncertainty, which there were two pieces of it. One is there was a agreement not to prosecute Hunter in the thing, and that was the first thing, that there was no meeting of the mind, she said, because Hunter thought it was a blanket agreement that once I plead guilty, I'm done with you, fucking federal government. And that's a great reason to plead guilty. And then the federal government said, not really. And we learned something really interesting.
Yeah.
There's still open investigations against him. They said that on the record. And by the way, there were at least 2 sealed sidebar conversations. So whatever was going on there, they don't want the public to know about it. So whether that's pending investigations, grand jury convening, cooperation, these are all the things that you're never going to know about. So there's something else going on here. That's what this told me, that we don't know about. But the bottom line is, she's saying 2 things. One is, Hunter, you think you're done by pleading this, but the government is saying they could still bring other charges against you, FARA violations, whatever.
And you're right, Doug, you're obviously 100% right, but that's why she wanted to get clear on whether she had the right to reject the plea or whether she was being forced to accept it as is. And the government was, I think, misleading her and saying that, no, this is a B plea. You have to accept it. You have no choice. You got to accept it. Just shut up.
They never
she was not having it.
Yeah, well, that's a dumb way to approach a federal judge. Federal judges don't have to do shit. The sooner you learn that, the better. But
just let me read. Read from the relevant portion of the transcript, because I think this is important.
Mm-hmm.
So this, so
where
Mr.
are you reading?
Wise,
what page? What page?
This is on the bottom of page 17. Here, actually, I could bring it up.
Okay.
Let me.
Because I got some. Because you're early on. That's the thing. Like, they went through this whole thing, and then they took a sidebar, and the 2 sides met, and they came back and said, "We're ready. We have come to a meeting of the minds." So whatever happened on page 17, might not be exceptionally relevant.
So in your view, I'm just reading from here. So in your view, what is my role here under Rule 11C1B? Wise, Mr. Wise, he's the government attorney. Your Honor has two roles, as Your Honor has already begun to determine that the plea is knowing and voluntary under Rule 11B. She hadn't.
Okay.
And to apprise the defendant that you are not bound by the recommendation of the United States in this case pursuant to 11C3B. The
Yeah.
court. That's it? Wise. That's it. The court. Now, all right. Now, is it my role to accept or reject this plea? Wise. It is not, Your Honor. That is wrong.
Yeah, that's totally wrong.
Always
Why would he say that?
Because he
Of
wanted
course
to
it's her
force
role.
it down. He wanted her to accept it and be done with it. No, don't look behind the curtain. Don't ask questions. He was going to screw Hunter. It wasn't a confusion. She wanted to tease it out on the record. I think she's
Yeah.
brilliant, frankly.
Yeah.
And maybe it's all that civil crap she has to deal
Yeah.
with. But
Yeah.
guidelines are just as obtuse and obscure as patent law. Trust me on it. Well, So I think that the issue here is he wanted her to accept this, so she was not going to allow the government to force her to accept this plea, thereby binding Hunter and basically making a factual finding that he was entering into it knowingly, and then they could bring charges later on.
Yeah.
Because that is really what that, and that's where it fell apart. Is
Yeah.
when she started asking, so Hunter, do you understand that you can still be charged with it?
Yeah,
Oh
and he
no,
was
I
like,
don't
"Oh
think.
hell no! What?
Oh no,
Yeah.
no. This is it." And she's
Okay.
like, aha.
Uh-huh. Now, but then they did take a recess later on down the road, and the two parties met, and they came back and said, "Okay, we agree what this language means. It only covers a specific time period. If there are other charges to bring, whatever it's going to be, FARA charges or whatever,
Yeah.
new charges for whatever agreements he's got with the Chinese Burisma or whatever. Yeah, they basically came back and said, "Yeah, I guess we can be charged with some shit now."
Right.
And I still want to plead guilty, even knowing that there could be more charges. That's
Yeah.
what happened, but it wasn't.
there's another
There was
problem.
another problem. Yeah.
Yes.
Go ahead.
Well, the other problem actually had to do with the pretrial diversion agreement.
Yes.
And generally, judges are not involved at all. And she was right on pretrial diversion. That's basically between the parties, and whether somebody has violated the terms of pretrial diversion, that's usually not a call that a judge is ever asked to make. Rather, that is something that the government unilaterally does. Say, "Hey, you breached the contract." And now we're going to go ahead, we're going to go forward with the charges, and they can litigate it at that point about whether there was a breach or not. But it's up to the government, or in some cases, the probation office. And what the probation office will do is and they talked about this. It's similar to supervised release revocation, where the probation officer will draft essentially a complaint and say that the supervisee has violated the terms of the pretrial diversion agreement, and there will be a hearing and everything on that. But here, what seemed to be different and what was throwing the court off is the court itself was going to act like that probation officer or the government. And now the court was injecting what the government and the parties, and Biden's attorneys too, was making the court essentially a party to the pretrial diversion agreement, which is to keep you out of court. So how could the court be in something that's supposed to be not in court, so to speak?
Yeah. Well, I have thoughts on that. And
okay.
And this is one area where I thought I didn't really think either side was making a lot of sense. But by the way, I have this page up about other charges just so you can see this. Page 50, basically the judge is asking, she says, "Is there an ongoing investigation here?" Mr. Weiss, page 50. He says, "There is." Did you hear that, everybody? There is. This is not the end of it for Hunter Biden. And she says, may I ask then why? If there is, we're doing this
You may
piecemeal.
ask.
Like, what the fuck are you even doing here?
Yeah.
Which is a great question for Hunter's lawyers. And I don't know if
Right.
that was news to Hunter at the moment or not, but it just
Oh, I'm
sounded
sure
like
it
it
was.
was. Yeah.
I am sure it was.
So
Yeah.
she says, may I ask then why the fuck we're doing this piecemeal? She didn't use
Yeah.
the F word. That's
Right.
my purview. And Mr. Wise, the U.S. the government's lawyer, says, Your Honor may ask, but I'm not in a position where I can say. And so
And then she
she's
was like, sit your ass down then.
yeah. And she's like,
It's so
look,
many
at that
words.
moment, she's looking at Hunter and his lawyers going, what the fuck are you guys doing?
Exactly. Exactly.
And I'd love to know that answer myself.
Yeah.
But anyway, the point is they reach an agreement where they go off together, and the defense comes back and says, yeah, okay, we get it. There could be more charges. We still want to go forward with this plea, but it's this, like you said, it's this into the breach. So
Right.
this is where two things, and I guess it filed this under practice pointer. This whole thing could have been avoided by the lawyers drafting this agreement in one of two ways or both. A, separate them out from the
Right.
tax plea agreement versus a diversion. And you don't even need to bring the diversion agreement to the court at that point.
Right.
Just have that as a separate agreement off the record with you and the government in writing. Because like you said, the court doesn't even need to be a party to that. But the first mistake they made is they wove it into this plea. Why did they do that? I'll tell you why they did that. Again, they want to dirty this motherfucker up. Sorry for the swear words. Please forgive me for my swear words. But if they don't have to have the gun, drug, dirty charge in there, because this little misdemeanor tax thing isn't really that serious and it doesn't make him look that bad, well, they want this on the record, because if they do a private agreement off the record, Joe Q Public and on Fox News doesn't get to complain about it and rail about it and talk about it. So I believe they wove that into this agreement solely to get it into the public record to make Hunter Biden look worse than he is. But that's my opinion. And I know you're kind of shaking your head going, I don't know.
No. I'm not shaking my head. No.
But they could have done it that way.
I think there's other ways they could have got it into the public domain without having to try to get it in the record, square everything up. But
it might have been more difficult. But okay, put that aside. They could have kept it separate. They didn't for whatever reason. What I see in my district, especially in District of Arizona, where I practice for most of my federal time, is they don't do a deferred prosecution. They do a they don't do a diversion, which I guess you could call deferred prosecution, meaning we're not going to prosecute this case. We're just going to put it in a drawer, whatever. They do what's called a deferred sentencing agreement. It's very, very similar, but with a significant difference. And that difference is you come in, you actually plead guilty to this charge, the gun charge. Yes, I possess this gun. Yes, I was using substance at the time. Yes, I'm guilty. And then you get put on pretrial supervision. You're supervised by the pretrial services agency for whatever, 18 months, 2 years. And if you get through supervision, then the case is then dismissed. Sometimes they'll drop it to a misdemeanor, whatever, but the case is gone. And so functionally, practically, it's the same result as a diversion, but you've entered a guilty plea on the record, which means that if you violate the terms, you've already pled guilty, so now you're getting sentenced. You proceed directly to sentence without pass and go, without collecting $200. But the judge is still always the gatekeeper to whether you get to proceed to sentence. In my opinion, in exactly the same way she would be the gatekeeper if the government was get to proceed with charging if he breached. It's the exact same thing, which is to
Okay, go ahead. Finish your sentence.
He is being supervised, even under his agreement for diversion. He is being now supervised by pretrial services. He has rules to follow. And anytime ever, whether it's pretrial, whether it's a diversion, whether it's supervised release, whether it's probation, whatever it is, the judge is always the gatekeeper between the defendant and a prison cell or a consequence. In other words, the pretrial may allege a violation. Great. That kicks off a process, which sends that violation to the court, which gives the defendant due process to challenge and litigate, did I really violate? Because otherwise any asshole could say you violated, and if I don't have a means to challenge it, then my constitutional right to due process has been violated. So this judge got wrapped up in lost the forest through the trees. She's saying, is this a constitutional violation? Because you're telling me that I have to find a violation, and if I find a violation, then you can charge him. That's what the agreement says.
Yeah.
And I'm not comfortable with that because only you, executive branch, prosecutor, Department of Justice, has the purview to decide whether to charge a person or not. And if I have a role in that, I'm squeamish about it because I shouldn't ever have a role in a charging decision.
Right. But I think that's correct, though, because there's a difference between the initial charge versus supervising somebody on probation or supervised release. They've already been charged and found guilty and all this other stuff. So that the court will have jurisdiction there to remand them, and it's not really necessarily a new crime. What a court does where there's a supervised release violation, which I think is a good example, all the parties agreed that it was, isn't finding a new crime. It's just it's an administrative procedure. There's due process, but it is just it is part of the original sentence that those terms of supervised release. So if they're breached, then revoking supervised release, sending that person to prison.
I think this is why people hate lawyers, because this is so much distinction without a difference in splitting hairs. The bottom line is let me finish.
Okay.
The bottom line is the judges are the last line of defense for constitutional violation.
Yes.
And if you couldn't go to the judge to determine if the breach of that agreement was legitimate and have a mechanism to challenge whether you actually breached the terms of the agreement, then that's the real separation of powers, because the executive branch could unilaterally just say, the new Trump gets reelected and a new DOJ comes in and they say, God damn, we hate Hunter Biden and we hate that plea agreement. So let's just say he breached it. I don't care if he breached it or not. Let's just say he did. And what mechanism would you have to challenge it at that point? You should have a right to go back to the judge. The judge should be the referee, the arbiter of due process. All right.
Wait. So, violating pretrial diversion does not result in a guilty finding necessarily.
It results in a charge that kicks off a felony indictment and eventually potential
now
prison.
They're going to prosecute. And guess what? You can fight that charge. He's not pleading guilty to it. He's not pleading guilty to. So let me give you an example, a real life example. You may have heard of this.
Who's the referee, Mark? No, I get that there's a difference, but I'm arguing what's the real significance of the distinction, because either way, a defendant is getting fucked without due process.
No, because he could always fight the charge. He can look. You've heard of this guy named Trump, right? He's looking at
heard of this guy named Trump.
Okay, so he's looking at, and for all I know, he's already been indicted in Georgia. Okay,
we'll be doing a podcast on that.
We're going to be doing a podcast, and maybe Drew Findling would like to join us.
Yeah.
Because this actually happens to be something that Drew Findling has recently, unfortunately, unsuccessfully litigated.
Yeah.
But what he tried to do in Georgia is Trump has not been charged yet. He tried to get the courts to intervene through a writ of prohibition to stop the court from even indicting or allowing, not the court, but the prosecutor there from issuing an indictment against Trump and saying it violated due process and all this other stuff. The Supreme Court of Georgia nixed that, said no, you can't do that here. It's up. We don't have, they brought separation of powers and all that stuff. We are a court. We don't make decisions on whether or not the government can bring a charge or not. Once the government brings a charge, now you can fight it in court. but there's nothing you could do before the government decides to bring a charge. That's the same thing with Hunter Biden with respect to the gun charges. Yeah, information has been filed as to those gun charges, but there is no admission of guilt. He could still fight those charges.
Yes, I understand
So
that.
if the
But what
pretrial
remedy
diversion,
does he have beyond that, which is spend $1 million on lawyers and run the gauntlet and hope you win at trial or get this? That's deeply unsatisfying.
Is the pretrial diversion.
Well,
But yes,
so let me ask you
but
this.
that's the risk you take that if you're offered pretrial diversion.
But you would agree if they did a deferred sentencing, then that the judge wouldn't have that issue. That would have been a cleaner way to handle this then.
Oh, I think so. Yeah.
Okay. So there's I guess a practice point, but can I direct you to 18? Now I'm getting a little geeked out. I'm usually the soft stuff. I'm the story guy.
Okay, bring it on, baby.
May I direct you to 18 United States Code Section 3148 entitled Sanctions for a Violation of a Release Condition?
Yes.
So the plea agreement contemplates that he will be supervised with conditions of release, correct?
Yeah.
And
the plea agreement or the pretrial diversion agreement?
The diversion. The diversion. Yeah. And there's a provision on there called Section B. Available sanctions. A person who's been released who's violated a condition is subject to revocation of release, an order of detention, and a prosecution for contempt of court. B, revocation of release. The attorney for the government may initiate a proceeding for revocation of an order of release by filing a motion with the district court. So let's stop there for a second. Okay. There's going to be an order for release, and the attorney for the government can say Hunter violated that release. Now then, what happens if they do that? This law says a judicial officer may issue a warrant for the arrest of a person charged with violating a condition of release, and the person shall be brought before a judicial officer in the district in which such person's arrest was ordered for a proceeding in accordance with this section. The last part of this says the judicial officer, ready for this, shall enter an order of revocation and detention if, after a hearing, the judicial officer finds either probable cause to believe a person's committed a new federal, state, or local crime while on release, or if there's clear and convincing evidence that the person has violated any other conditions of release. Doesn't this code 3148 contemplate that you cannot do anything with a person until a judicial officer has made a finding that Hunter Biden there's enough proof that Hunter Biden has violated his conditions of release? Yes.
That has nothing. No, it has nothing to do. That has to do with supervised release or
no, it doesn't.
Release.
That's pretrial release. This is pretrial diversion. This is a pretrial diversion agreement. He's going to be on pretrial release. How can you say that has nothing to do?
Because he has not been released under 3142. If you look at 3148A, a person who has been released under 3142 and who has violated a condition of his release. This is pretrial release, but that's not what's referenced in the pretrial diversion agreement.
But what I see is the court saying on page 8, I understand that pretrial release. I agree that pretrial release is appropriate, subject to the following conditions, which I will read into the record. And then she reads in all the conditions and says you've got to do this, that, and the other thing. And if you violate those, you're going to be may result in immediate issuance of warrants for your arrest, revocation of your release, order for detention, forfeiture of bond, prosecution for contempt, and imprisonment, fine, or both. Do you understand that?
So look, what I have up here on my page, this is the diversion agreement. Okay. Pertaining to the.
Are you sharing that? Yeah.
Yeah.
Okay,
it's shared.
Yeah.
Can you see it?
Okay.
Well, okay. So here's breach of the agreement. This is on page 6 of the agreement for those out there
Yeah.
in cyber world. It's document 29-1
Well,
for
wait.
case.
We shouldn't get to breach yet. We should get to the part that says whether he's on what his if he's on pretrial release or probation. What that part, right? Diversion terms and conditions
Yeah.
shall be 24. The terms of this shall be 24 months, unless there's a breach. Blah blah blah. That's the diversion period, and waive the indictment in relation to the information. So listen to this though. He's charged with an information, which means he's fucking on pretrial release. There's an information, and they're diverting. I mean, that's every defendant in the history of the world. They're either charged with an indictment or information, and then they're released on conditions.
Right.
So why is that not this guy?
No, it is. He is also on conditions of pretrial release for the felony information. But what we're
Right.
talking about here is the pretrial diversion agreement.
On
That is
the
something
felony information.
of the felony information, right? This is
Yeah.
a separate agreement. This is a
Pretrial.
separate
It's right
agreement.
there in the title. Pretrial. It's he's
Yeah.
pretrial on this case. I don't care if it's pretrial release or pretrial diversion. He's getting pretrial supervision, and that statute applies to him.
Yeah, it does. No, I agree. I agree. But the
Well,
reason
wait,
why I'm getting,
you what? Could you say that louder? Come
I
back.
agree.
Can I just
agree
win
with
this
you.
argument?
I agree with you, but that at his pretrial diversion or his pretrial release technically
Just
has
say
nothing
uncle.
to do with his
Just say
pretrial
uncle.
diversion agreement.
Oh,
That is why
that's lawyer. That's crazy lawyer talk.
It is crazy lawyering. This is why she was confused. Let's get down to
I really hope she hears this podcast.
yeah.
She's gonna laugh. She's
right.
gonna be laughing her ass off when she hears.
Yeah, well, she was right to be confused, and this was lame the way they did this thing.
I don't think the lawyers are gonna find this too funny, but that's okay.
No. So look at here at page 6. Here's the breach of the agreement. Now look, look at paragraph 14 here. If the United States believes that a knowing material breach of this agreement has occurred, it may seek a determination by the United States District Judge for the District of Delaware with responsibility for supervision of this agreement. Okay, that has nothing to do with pretrial diversion. Or pretrial release. If he violates pretrial release, that's a probation officer that files a complaint and starts all of that stuff.
Or a pretrial.
Not the judge. Not the judge. This is why she was confused.
So then, all right. Well, I will give you this because this is really shitty drafting, and I will imagine behind the scenes though that this is how this conversation went. The defense lawyers wanted this in here because they're terrified that if there's a new sheriff in town, all bets are off. And the DOJ could do something crazy like they did with Michael Cohen, where they threw him in jail because he wanted to write a book, and they needed to build some due process in there, and they insist on this language. So kudos to them if that's true, but they did it all wrong, and that is what sounded the alarm bells and rightly made this judge skeptical of this agreement, because first of all, it's usually a magistrate that makes that determination.
Right, but look at the remedies. Wait, Doug, look at remedies 1 and remedies 2. The remedies for breach of the pretrial diversion agreement are not to remand Hunter Biden. They are either to give him a chance to cure the breach, or if he doesn't cure it within a specified time period, then the United States may prosecute Biden for any federal criminal violation of which the United States has knowledge. So they could that's why this is separate from the pretrial release. Now, he also can be remanded for.
Well, there's one more part to that remedy, which is the United States isn't required to offer remedy 1 before proceeding to remedy 2 if in its sole determination the nature and seriousness of the breach warrant termination of this agreement.
Yeah, so but one of the point is
so they got too cute by half with this language.
They got too cute by half, which is why when we go to the transcript and we look at
maybe that's the title of this podcast then. Too cute by half. And sometimes over lawyering the fancy bottle is what fucks you. It's too much lawyering that's going on here. Okay.
So, but see,
Interesting.
this is why I'm drinking my water from Dalian, China. Keeps my brain a little bit more following all this massive craziness than nice tequila. But but if you look at, I'm just joking with you. If you look at page 95,
Yeah.
so here, actually, let's start up at page 94 of the transcript. Um, so the court, as I read it, tell me if I'm reading this correctly. And this is the diversion agreement. That under the diversion agreement, as you all drafted it, the only way that charges could ever be brought is if I, the court, have the hearing that you all agreed that I have to have, right? The government.
Yes.
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 The court. So if I don't have a hearing or make a finding, no criminal charges can be pursued for the gun charge or any other federal charge within the scope of the agreement not to be prosecuted, right? The
Yeah.
government. I believe that's right, Your Honor. The court. So if there is some requirement that you have that I have to make that finding that you all agreed that I would without asking. So is there some requirement that you have that I have to make that finding that you all agreed that I would without asking me? And then he responds, there's some, and then she says, requirement that says I have to make that finding. No, there is none. Now, and you don't have any precedent for that, right? No, Your Honor. Ballsy. And this is to keep by half right here. And so now here's the key part. So the court, do you have any authority that any court has ever accepted that or said that they would do that? Meaning this procedure where she makes the determination whether there's been a violation of a pretrial diversion agreement.
This is still back to what
no,
I
Your
say.
Honor.
That's every case ever in the history of criminal cases.
No, it's not.
It is.
She's talking about the pretrial diversion.
It is in pretrial diversion. It is in pretrial release. It is in supervised release. It is in probation. Every single fucking time there's going to be a judicial finding. So if now we're going to split hairs whether it has to be her versus a magistrate, come on. Every single time.
I'm not splitting hairs like that. Find me a pretrial diversion agreement that says that the judge makes the decision about whether this pretrial diversion.
You don't have to find a pretrial diversion agreement. You only have to look to the statute about what happens if you violate the conditions that the court has set for you. She's setting these conditions. You violate the conditions, the court makes a finding, then you're fucked. That's how the system works.
That's the separate issue. It doesn't matter.
It's not.
Yes, it does. That's what the confusion is.
This is bad drafting, which leads to all this splitting hairs and confusions. But the essence of the essence of what they're asking her to do is what every single defendant's rights are in any single case, which is to have an independent finding about how fucked you are for violating the rules that this court set for him. Because those rules only ever come from the judge. The judge sets the rules of pretrial supervision. The judge sets the rules of pretrial release, supervised release, probation. These are all rules the court says, you better follow these. If not, you're going to be back here. And if I find that you violated these rules, there will be a consequence. That consequence could be you're going to stay in jail pending trial. It could be we're going to revoke your probation and sentence you to the Bureau of Prisons. Or in this case, it is you're in breach of your pretrial diversion. And guess what? The government is free to prosecute you if they so choose. But ultimately, the judge doesn't have to tell them one way or the other what they should do. That is always and was their prerogative and always will be their prerogative. And I think the judge is flat out wrong here. And I will go to my grave thinking that. But clearly, we're not going to agree. Which is fine.
Well, I don't know if you can see this on the screen, but this is just a pretrial diversion agreement that I found out of the District of Kansas, a recent one. Can you see this for the United States versus? Okay.
Yeah.
Okay. So this was filed not too long ago, just last month. And there's nothing in here about the court. The court has to make a finding that there was a violation
Well,
Should you
I agree.
violate the conditions?
Okay, go ahead.
Yeah, should you violate, the United States Attorney may revoke or modify. The United States Attorney may revoke or modify any conditions of this
I
pretrial
still,
diversion
but
program.
implicit in that is if you violate, you're going before a court to, then they're going to make a finding of that you violated, and then should you violate, the U.S. attorney may revoke or not. They can't just on their own say, "Hey, I think you did something wrong. Now I'm going to
Yes, they
do this."
can.
No,
See,
they can't.
here the
Oh
charges have
God,
not
if
even been
that's the
filed.
world you're advocating for, I'm
I'm not.
terrified. Oh
I'm
my
not
God.
advocating for it. I'm just telling you procedure. You're
Oh
confusing.
God.
You're confusing the pretrial release where charges have been filed with
Doesn't
pretrial
matter. I'm not
diversion.
confused, Mark
It both
Allenbaugh.
the both
I'm
have
not
happened right.
confused. I'm
Okay.
saying there's no meaningful distinction. It's all pretrial release. It's all conditions set by the court, and it's all due process. That's all. That's all I'm saying. I'm not confused. I may be wrong, but I don't think I am. But I'm not confused.
Okay. 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 I'm with you.
All
I'm
right.
with
Well,
you.
I think we've beat this to a dead horse, and I don't know. We're gonna have to let the audience decide if this is a who won this fight or whether it's a draw. Win,
Well,
lose, or
you're right.
draw.
I don't think that's the important issue. I think the more important
It's
issue.
definitely we're lawyers. We want to win.
Well, it's understanding plea agreements and understanding that pretrial
Oh,
diversion,
is that what we're
pretrial,
talking about?
yeah,
That was that was like 6 years ago, but okay,
right.
good.
Pretrial diversion agreements are a rare thing in federal court. If they're not
Yes.
drafted well, they can cause a lot of
Yeah.
problems, like they have here.
Yeah.
Um, plea agreements likewise can cause a lot of problems, and their contracts as well. And
Yes.
there's a variety of different
Yes.
ways to plead guilty. The way Hunter Biden, this, and I haven't used any foul language, so I get my one Catholic opportunity here to say this was a complete clusterfuck.
Yeah.
And I think you should call this
Good work.
episode Too Cute by Half, because all the parties, I don't think the government realizes that there's no, I don't think the government realizes that a court can reject any plea agreement, whether it's A, B, or C, and
Yeah.
doesn't have to accept, be force fed any plea agreement.
Yeah.
And likewise, the court doesn't really have a role
Yeah.
in pretrial diversion agreements.
Yeah.
And that's what was causing all the problems here.
Well, I agree with everything you just said, and I
And
will
Hunter
add.
didn't understand. It was
Oh,
very clear that
clearly. And
Hunter
Hunter's
didn't
a
understand.
lawyer. Hunter's
Yeah,
a well-educated.
yeah,
But
yeah.
here's the thing you said, diversion agreements are rare, and that is true. And I would hope one takeaway from this whole conversation is it shouldn't be that way. That and even Merrick Garland said we should be doing this more. But if you're an attorney, and we've talked about this before, pretrial diversion or deferred sentencing, whatever you're
Yeah,
going to do, is a thing, and you
yeah.
should be asking for it as often as you can. You're not going to
Yes,
get it. You're not going to get it all the time, but God damn it, why don't you
yeah.
try?
Ask.
Because the
And the commission is
consequences.
looking at it. The U.S. Sentencing Commission, one of their priorities for this coming amendment cycle is looking at pretrial diversion agreements and finding a way where they can start increasing the use of them.
Yeah.
And they
So,
should do that.
and so the second little thing I have just to kind of maybe put an ending to this story is they got over the first hurdle of can we bring additional charges? They came to an agreement and they started going forward with the whole plea, and they got all the way almost to the end. And it was this thing, this that we've been screaming about at
Yeah,
each other about, that ultimately the judge says not doing it. And
yeah,
so if this thing wasn't part of that, she was worried that if this thing was bad, that the entire plea, the other thing would fall with it. And so she
correct.
was very, very concerned, and she didn't,
Yeah,
and she was put the brakes on, and
yeah,
everybody left saying no deal, and they
yeah.
walked out. And
Right.
so I don't
Kudos
know
to
if
her.
yeah,
Kudos
good
to
for
her.
her.
Yeah.
And I wish I was a fly on the wall in the negotiations that are happening now with these two parties, the government and Biden, but they're either going to try to fix this and get back into court probably soon, or they're just going to say, forget it. Do what you're going to do and we'll see what happens. But my guess is that Hunter
Drop the gun
wants,
charges. Just drop them.
yeah, or just do a separate deal
Mm.
or do it. I don't know, but they have to fix this, and I guess we've given them some pretty good ideas on
Right.
how they
And
could and
and
should.
by
But
the way, and I say, and I say drop the gun charges because they are causing a mess to resolving this issue. The government can still get its pound of flesh because the plea agreement on the tax is a B plea and it only provides a recommendation for probation. Given that the tax loss is over $1 million here, I highly doubt that this court is going to give him probation, given that amount of
Really?
taxes. Really.
And
If
she
you look
doesn't
at,
have to because it's just a recommendation. It's a B
right,
plea,
she
like
doesn't
you
have
said.
to because it's just a
Yeah.
recommendation, but also hope to God she doesn't call sentencing stats and we tell her what's going on out there in the real world for tax loss cases of $1 million, because those guys are getting around 12 to 14 months on
Yeah.
average.
Yeah. So
That's what he
that
may be
does
looking at.
suggest a sweetheart deal. Now he did pay everything back, so I'd be kind of interested
That
to
doesn't
know.
matter.
Well,
Yeah.
it's mitigation, but yeah, no. But you know what? Back on
It
the
is. It's mitigate. No,
by the
you're right.
way,
It doesn't matter. It doesn't matter for the guidelines calculation. It does matter for purposes of mitigation. You're absolutely
yes.
correct.
I got to go back real quick though, because this is an important point, and it's one that I forgot about even when I was looking at that 3142 and the burden of proof and everything else. If
Yeah.
you look at the quote unquote deal they negotiated, these high powered, high dollar lawyer on page 87, paragraph 14 provides that if the United States believes that a knowing material breach of this agreement has occurred, it may seek determination by the United States District Court. Obviously, that's the problem. But did
Yeah.
you notice the burden of proof that they said the judge should use to determine whether?
Preponderance of the evidence.
Yeah. And guess what? That's not the burden of proof for a violation of pretrial, which is essentially that's what the breach would be, is a violation of the terms that are set. It's clear and convincing evidence. And I forgot all about that. But if you look at 3148, I think I said 3142, but if you look at 3148, you have to have clear and convincing evidence that the person has violated any other condition of release. So the lawyers sold Hunter Biden short by lowering the burden of proof for a violation here. They should have gone for clear and convincing evidence.
Absolutely.
That's a little bit of
that's a
in
problem.
the weeds. It's in
Yeah.
the weeds,
No,
but it's
it's not
not,
in the
but it's
weeds.
not
That's huge.
insignificant.
Right.
It's not insignificant.
Yeah.
So there are a lot of little things like that, stupid little things that a lawyer with more, I don't know, like, you know, we talked about this before we even recorded, but you know, the judge says, well, okay, so we're not doing this plea. Do we need to have a preliminary hearing? And they said, well, we waived the hearing. And you asked the first most important question, which is, why the fuck would you waive a preliminary hearing? It's the first finding of probable cause. Why not put the government to their proof? It's maybe a low burden, but whatever. But the more important issue is there's no right to a preliminary hearing in this case
for
because
misdemeanors. Right.
Well, for misdemeanors, and it's rule 5 point, guys, look it up. That's really interesting. When I hate the law never helps me ever, and the case law never helps me. Sometimes the sentencing stats help me, a lot of times, but look it up. 5.1 Federal Rules of Criminal Procedure. If the government files an information, which is what happened here, charging the defendant with a felony, which is what happened here, you don't get a preliminary hearing.
Right.
And the judge didn't know that either. Bless her heart. Again, she doesn't see that many criminal cases,
right.
So I wouldn't expect her to.
Hey, so Doug, one last important point that we haven't discussed yet, and that's the tax loss. And it ties back into the different types of pleas. As we know, the plea to the two misdemeanor tax cases is a B plea, which means any recommendation, and there's a recommendation for probation, is not binding on the court. And each of the misdemeanors carries up to a year of imprisonment. So you add those two together to get the overall statutory maximum. So it'd be 2 years. So Biden's exposure is up to 2 years of imprisonment. And again, the government's asking for, or the parties are recommending probation. I don't think, like I said, I don't think the probation is an option here, but there's two. I should say,
it's an option.
Of course, probation
don't think
is
it's
option.
going to
I don't think it's likely.
Yeah,
I don't think it's likely here. And there's a couple of big things though that we can discuss this next time, but I want your listeners and viewers to really pay attention to this, and any news people that might be watching this. Page 24 of the plea agreement discusses the tax loss. And the tax loss is agreed to be between 1.2 million and 1.6 million. That spans two different levels. That's either a plus 20 or a plus 22. So if he gets acceptance, and by the way, his tax loss may end up being more. This is just what the government is recommending. The parties recommend. The PSR may find it's higher for some reason.
Yeah.
So if it's a 20 if it's a 20 and he gets 3 off for acceptance, then over the last 5 fiscal years, there were 168 defendants that were sentenced under 2T 1.1 that had a total offense level of 17 and criminal history 1. So the average sentence there was 14 months and the median was 12. But it also could be a 19 could be his total offense level if the probation office finds that the tax loss is greater than $1.5 million, and he's agreed to that. It could be greater, it could be up to 1.6. In which case, there were 76 defendants over the past 5 fiscal years with an average sentence of 16 months and a median of 15. So the point is there, that's not huge sentences in the grand scheme of things, but it's a hell of a lot more than probation. But there's one other issue here, and this is really getting into the weeds with tax fraud. On page 35, the government notes that the tax loss that we just discussed, they agree that it is without inclusion of the penalties and interest. That is, and maybe I should say this secretly. I don't know if anyone, and please forgive me, Hunter.
I can bleep it out. Bleep.
Okay, well, you may want to bleep this out because it's a mistake in his favor.
Yeah, you don't get to count penalties.
Normally,
interest,
you
right?
don't get to count unless the charge was willful failure to pay the income tax.
Gotcha.
And he was charged in both counts with willful failure, in which case it all comes in, the penalties and interest, and that could be a shit ton. And so he may be looking at an even higher offense level as a result.
And
this is something that the pre-sentence, the PO may catch, although this PO probably doesn't have a lot of tax cases. So hopefully,
but everybody's listening to this podcast, so certainly she'll hear this. And sorry, Hunter, we just screwed you bad. But I'll tell you what. Go ahead. Did I interrupt you?
I was just gonna say, now's the time to renegotiate everything and get everything fucking right.
Yeah, right. Yeah, you got some work to do on this. And I will say, just by the way, and one last interesting point on this whole thing, it's the idea of third parties, and this is a very unique thing in this case. But I thought of it when you were talking about the tax loss, because there was something in this thing that said a third party paid all that tax.
$962,000.
Yeah. So doesn't that make you the least bit curious on who this magic benefactor is?
Well, not only curious about who that magic benefactor is, but I now rescind my prior statement about payment of the taxes being a mitigating factor, since Hunter
he didn't pay it.
Didn't do it.
Right.
Correct.
He didn't pay it. So I'm hoping there's a good, helpful story around that. And I'm really hoping it's not dad that bailed him out. Although, what else are dads for but to bail out their sons? I know my dad's bailed me out on more than one occasion, and I'll probably be doing the same for my boys. But the other third party thing that I think is really interesting in this case, and it may have a bearing on how this whole thing unfolded, which is somebody filed, and I didn't pull this thing, but somebody filed a third party a brief, basically weighing in on the propriety of this plea agreement.
Oh, yeah, it was a member of Congress.
Oh, yeah. I remember requesting this judge reject the plea agreement. Quote, I'm reading from page 20 on the transcript. They requested that I reject the plea agreement based on information that the filers submit cast doubt on the investigation performed on the charges brought or both. So basically, they're saying whatever the U.S. attorney did. They didn't investigate this right. These charges, this plea is not right. Reject it, and reject it for that reason. And that is balls. Have you ever in a million years imagined
Never.
that would ever? It's never happened.
Never, and frankly, the judge should have struck that from the record because nobody has standing to object to whether a judge accepts or rejects the plea agreement, other than the judge herself and the parties.
That is, talk about your separation of powers. You got a member of the
shit.
You've got a member of the legislative branch telling a member of the judicial branch, who, by the way, is appointed by the president for life, what they should or should not do in a plea agreement.
That should have been stricken.
Fuck you.
Yeah,
sorry.
That should have been stricken. That was bullshit.
But I will say this, I don't know if this is true or not, but it's it's the highest of high profile cases.
No, it's the second highest.
That's right. It's the second highest. But the point is, this judge is fully aware that all the eyes of America are on this case, and all the news and all the press and all the scrutiny. And so she may give this level of scrutiny to every case that passes her bench, and I'll give her the benefit of the doubt.
Well,
I feel like a lot of this may be that every step counts, because if you make a misstep in a case like this, the whole world's going to know about it.
Yeah. Well, apparently.
Yeah.
We will.
We will. So, good luck to the legal team in negotiating a new plea offer. Hats off to the judge for her amazing eye and strict scrutiny. And now I believe it's time for me to have a nap. I'm going to crawl into bed with a big box of Costco crackers. I'm thoroughly exhausted after this conversation. And anybody wants to weigh in on who won that fight, that argument, who won that legal argument? Come on, bring it. I want the comments in the YouTubes. I want the comments in the iTunes. I think I got you this time, man. I really do.
Okay. Well,
that might be a first. That might be a first. Mark Allenbaugh is a legal genius, a giant. When it comes to all things legal. So anyway, boy, oh boy. All right, we're going to sign off for now, but that we'll be back soon talking to you about great sentencing issues. Thanks for coming. See you soon. That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.